Back as lawyer David Hollingsworth here to answer your questions about the law. Leanne.
We do, Graham, and it's interesting, JJ can say freezing rain or a snowstorm, and when you're a personal injury lawyer, you know that is going to result probably in a week's time with phone calls as a result of slips and falls. David, it's the season, it's the time of year.
Right.
Let's talk about liability for homeowners, because it's very different for a personal homeowner versus a public space owner or the municipality.
Right, so that's right. I mean, we get lots and lots of calls, people who slip and fall and hurt themselves, and they want to know what, if any, recourse they may have against the property owner. And you're right, so if it's a municipality, so if you slip on a city sidewalk or something like that, of course the city has the obligation to remove the ice and snow from the sidewalks, but in order to prove that they're liable to you have to show that they're grossly negligent. Okay, so that means that not only that they maybe didn't have an adequate policy in place, or if they did have an adequate policy in place, that they didn't follow it. So they may have several hours to get to the sidewalk before they're required to make sure that it's salted and sanded, whereas a homeowner, you have to be on top of it a little more. Somebody just has to show that they were negligent. In other words, there's a foreseeability that there's going to be a problem, there's going to be a hazard, and you have to be on top of it, because otherwise, you're going to be liable to somebody who hurts themselves.
So I'm thinking of someone who lives alone, perhaps someone who is elderly, has a long laneway, and it's glare ice. It's dangerous for them to get out to salt or sand it as well. What if they put a barrier at the end, a pylon or something like that?
Right, so if it's any property owner, then the law protects somebody who prohibits somebody from going in, or provides a fair and adequate warning that, listen, you're entering at your own risk here, that it's icy, it's dangerous, because it's foreseeable that if you have a laneway, somebody's going to come onto your laneway. So you have to keep it safe, but if you want to restrict them from coming on, you can do that. And if somebody hops a barrier, well then they've assumed certain risks on their own. So they'll be probably found to be liable themselves for hurting themselves.
But if you're not maintaining your snow removal or ice removal, does that make your insurance policy sort of precarious, or would it void a policy?
Well, I don't think it would void a policy, but certainly if you have a claim or multiple claims, your insurance premiums, and maybe insurance companies may be a little reluctant to give you insurance in the future. One thing I just want to mention quickly, if you do slip and fall and hurt yourself on a city sidewalk, there is a 10-day notice requirement. So you have to put in writing to the city within 10 days when and where you fell and that you're considering making a claim.
That is big news. See, I always thought there was a statute of limitations and a certain period of time, but not for city property.
Well, there is. I mean, you still have 2 years to start your lawsuit, but they want to give the city the opportunity to go out and inspect and repair, because the city's such a big area, they're at a bit of a disadvantage if you tell them 2 years later, oh, by the way, I slipped on such and such a sidewalk. It's difficult to defend against. I mean, there are ways around it if you don't provide them with the 10-day notice, but it's fairly important.
I did mention the pylon as an example at the end of a laneway, but you said just in the commercial break that you just had a case where a pylon was used when a floor was being mopped, and that didn't serve as adequate warning or protection. Give us the sense of that without revealing, I guess, the details you can.
Sure. So basically, there was somebody who was mopping, and they put a yellow wet floor sign down, and the whole purpose of the wet floor sign is to provide people with notice of a hazard. But this wet floor sign, we argued, was not put in a place that it was visible to the person who ultimately slipped and fell, so the sign was ineffective. So in order to provide proper notice, the notice has to actually be effective for the people it's intended to protect.
And you were able to determine that because of cameras?
We had cameras, yeah.